ready to record now. It's not playing yet.
So we're now on and ready to go. Welcome to this online seminar on the taxation of crypto assets. Thank you so much for joining us. It's fantastic to already have so many people here, and hopefully we'll get a few more. I am here with Ben, who is another barrister from Old Square Tax Chambers. I'm a barrister from Old Square Tax Chambers, practicing in England and Wales and in Jersey and the Channel Islands. So what we're going to talk about today is some of the issues around this rapidly developing topic. Bear with me one moment, please. This rapidly developing topic in which there is still a great deal of uncertainty. So that's fantastic for us lawyers, but less good for all of our clients. So the way it's going to work, I am going to cover some of the material, and then I think Ben is going to come afterwards to comment, and I think he tells me he has some really whizzy slides, so I'm looking forward to seeing those. So the first thing that I want to do is, if you remember back to sort of 2 or 3 years ago when these issues were first arising, one of the issues that we had to address was that the initial impression of those involved with crypto assets, so sort of the technical people who were very good at the technology, but maybe didn't have a lot of experience with business or accountants or tax and things like that, felt there was sort of a general feeling in the industry that because the asset class was so novel, it was not going to be susceptible to taxation. Now, that has been that sort of rather optimistic view has been dispelled. However, and particularly when one looks at it in a global manner, taxation of crypto assets does pose certain difficulties. But taxes and taxing authorities have seen many novel asset categories in their time, and so really they know how to deal with it. And I think what it comes down to is, if a crypto asset has value, then we're going to find a way to tax it. And that is exactly what's happened here. So in terms of what I'm going to be talking about, I want to talk about first, I'm going to sort of give you what I call my lawyer's introduction to the technology. And this is very non-expert, but in terms of having to advise on taxation of crypto assets, I've had to get what I think is a basic but accurate understanding of how it works. And I want to make sure that you have that as well, because what that gives us is sort of the factual matrix with which we're going to have to work. So to take the example of, say, Bitcoin, you start with a user who initiates the whole process. Software will connect to the first node, node 1, via a peer-to-peer network. Node 1 checks 2 things. It checks if the amount in the Bitcoin wallet has been spent and if the user has used the correct private key in order to access it. If node 1 can legitimize these matters, it transfers that information to all the nodes in the network, and they do exactly the same thing. They check if the amount has been sent and if the user has entered the correct private key. In this way, all the nodes know or learn about the transaction. This then moves the transaction to the memory pool, which is sort of a pool of pending transactions like a waiting room, before miner nodes will seek to mine the Bitcoin, seek to mine the Bitcoin. And the way it does that is by solving a problem. If it solves the problem, this creates a candidate block, and the candidate block is added to the chain. So that's the mine. Obviously, there are now other methods of production of assets, but that's the mining method where we started from. And I hope that what can be seen there through that example is that we have this medium of exchange through a computer network that isn't centralized. And of course, it's this decentralized nature of the value that potentially causes issues for taxation. The digital ledger is spread out across all these different nodes, such that it's very hard to pinpoint where it is. And of course, tax is still very analog in that many of the ways that we look at where and how things should be taxed relate to where they are. The distributed technology means that components are located on different networked computers running programs by sending messages to a process, which then runs the code on that infrastructure. So it's difficult to pinpoint at any one time where a crypto asset is, or where the amounts arising from it or the income arising from it is sourced. But it has to be said that this is not a novel position. If one thinks about intangible assets, then one realizes that this is something that we've all had to deal with before. In particular, if one, say, looks at a debt is not tangible. It may be given tangible form, for example, by being in the form of a specialty, but it is not a real thing. And so we've had to develop, mostly through case law, ways to deal with it. And so you get the confusion that we've seen in recent years, or the confusion, the hopeful partial or full straightening out of the confusion around how one determines source of income from such debts and where they're situate. And so my view is that we are probably going to end up in exactly the same position with crypto. It's not that this is an insurmountable issue or that insurmountable issues arrive. It's simply that we haven't quite worked out where we are with it all yet, but we are getting there. So for me, when we're looking at these types of assets, the important questions are the following. First of all, where is any crypto asset in question going to be subject to tax? Whether that tax is on income, gains, or capital, and on what occasions will tax arise? What are the chargeable events, and how should that tax be declared? Those are sort of the key tax points, but equally important from the perspective of our clients is the administrative burdens that go with that with that taxability. And I'm primarily saying there the crypto asset reporting framework, which is obviously a very important matter. And I've mentioned that because I mentioned this because it just shows how important it is. I am producing a brand new edition of my book on international tax reporting frameworks, written with Graham Jackson, simply because we really do need to include the crypto asset reporting framework, CARF, in that. So those are the things that both Ben and I are going to be looking at today. And I should say, I'm sorry I don't have slides. I'm not a massive fan of slides. However, my notes will be available. I've got about 6,000 words, not all of which I'll be saying to you in the time that I have, but I've got about 6,000 words, which will be sent to you afterwards. So moving on, the first thing that I want to look at is how we determine where crypto assets or income gains arising from crypto assets are taxed. Now, what we have is an awful lot of people's views on this. So we have some case law, which is obviously law, but we also have the revenue manual, we have OECD guidance, we have the law commissioner, the law commissioner's report, we have the crypto task force final report. And so we have a lot of opinion, which doesn't always line up, but it is worth looking at it. So it is necessary to understand the features of the asset that you're dealing with, and not all crypto assets are created equal. Most are going to be one of either an exchange token, a security token, or a utility token. And in addition, exchange tokens may be what are referred to as stable coins, which doesn't really make any difference for tax purposes at the moment. So my apologies if I can continue. Exchange tokens, that's things like Bitcoin, which utilize a DLT platform, not issued or backed by a central bank or other central body. They differ from security or utility tokens in that they do not provide rights or access, which is what security or utility tokens do, but they can be used as a means of exchange or for investment. So a security token is usually going to be a specified investment within the Financial Services and Markets Act 2000 Regulated Activities Order, and they provide rights like ownership, repayment of a specific sum of money, or entitlement to a share in future profits. In addition, they can also be transferable securities or financial instruments under MiFID II. That's the EU's Markets in Financial Instruments Directive 2. So security tokens do look very different to normal exchange tokens. Sorry, my apologies for stuttering a bit there. I've just seen we had a question. What is a node? As far as I am aware, a node is just one of the computers being used in the network, which creates the DLT. So I think that's the answer. But as you can probably tell, I am not a technology wizard by any means. And what I know about the underlying technology is what I have learned through advising and what I've needed to learn in order to advise on things like situs and source of income. So I'm sorry if that's not the best answer in the world, but hopefully that is an answer. So to come back to exchange tokens, security tokens. So security tokens look fairly different to exchange tokens. Utility tokens can be redeemed for access to a specific product or service that is typically provided via a DLT platform. So utility tokens, yes, they do give rights, and so they are an asset in that sense, and also in the sense that they have value. However, the taxation of them isn't going to be particularly difficult. In many cases, I think what we're going to find going forward is that the taxation of utility tokens might look pretty similar to the taxation of things like club card points. Is that Tesco? Club card points and things like that. And then just another brief, as I said, stable coins are usually exchange tokens. You are a stable coin if the value is tied to that of a currency, commodity, or financial instrument. That does not make stable coin a currency in a tax sense. And I think that's something that's really important to note. These things are not currencies in the way that British pounds or US dollars or any other central currency is. It is a currency. So I prefer to refer to them all as crypto assets and not as cryptocurrencies, because they are not a currency in the essential ways that they would need to be for tax purposes. Now, it is worth noting, and the OECD have a lot of great data on this, it is worth noting that many countries are planning or have in sort of like trial phases cryptocurrencies which are a form of centralized bank currency. And so that is happening, but I'm not going to talk about that today, simply because the taxation of that is going to be very similar to the way in which normal currency is taxed. So we don't need to go into that. But being a stable coin from a tax perspective shouldn't make any difference to the treatment of an exchange token. So what I'm going to talk about primarily is exchange tokens. And I think at the outset, before I move on to the principles that apply, it's very important to remember that things like situs and source and whether something is a trade, they are very fact-specific situations. And so it's not possible to scoop all crypto assets up into a basket and say, this rule will apply. So your starting point in dealing with them is always going to be what your facts are, what that crypto asset looks like, what the features of the owner of it are. So that is a theme that runs through everything else that I have to say today. But in essence, there are two bases on which a taxing jurisdiction is determined, and that's if you're talking about situs and source of crypto or situs and source of anything else. Situs, which in the UK is generally only relevant for inheritance tax purposes, is sort of the location of a thing. And this was considered the difficulty with some of the case law that we have on this, or in fact, I think all or almost all of the case law that we have on this, is that it's being determined in a different context, and that is in arguments about jurisdiction. So in which court the people can argue about ownership of the asset, or quite often whether or not the asset has been fraudulently acquired. So the law that we're looking at here, as it exists at present, is quite often outside of the tax context, which means that it doesn't always sit comfortably in the tax context. So we had the High Court in Fetch AI back in 2021, where what they said was this was in the answer to a submission that crypto asset was property located in England, because there was in essence the country where the owners of the asset concerned were located. In that regard, I adopt with respect the conclusions reached by Justice Butcher in Ion Science and Persons Unknown. The lex situs of a crypto asset is the place where the person or company who owns it is domiciled. So this is slightly confusing in a tax context, because what is really being adopted here is a test of residence of the owner. But Fetch AI uses the words located and domiciled, but if you read the whole judgment, what you can see from that is that domicile doesn't mean common law domicile, as you and I would understand it, but means sort of where somebody belongs, the sense often used in double tax agreements, if you like. And that is one of the ways that you see that this is in fact the area in which the cases are being decided matters, because that's possibly how a practitioner specialized in private international law thinks about domicile. So the question there is really, where is the owner of the crypto asset resident? Now, located, we look at how that was defined by the High Court in Tulip Trading. Obviously, Tulip Trading has now been to the Court of Appeal. However, it's not discussed by the Court of Appeal, and my view certainly is that what was said by the High Court in Tulip Trading remains. So, importantly, what do HMRC think? HMRC largely agree with this, saying in their crypto manual, where the crypto asset is an asset distinct from any underlying asset, then HMRC's view is that none of the statutory rules in the TCJA 1992 apply. For inheritance tax, common law is relevant to the extent that double taxation agreements do not determine the location. So HMRC's view more generally is that using the residence of the beneficial owner of the exchange tokens to determine the location gives a clear, logical, predictable, and objective rule which can be easily applied. And this means that if you hold exchange tokens, then if you're a UK resident, you're going to be paying UK tax on them. Now, there's a little wrinkle here. HMRC says that that is going to be determined by the statutory residence test. Some people disagree with that. I think I probably do, but I would need to look at that in detail. Practically, it's probably not going to arise, because there are going to be very few circumstances where you would not be resident under the statutory residence test, but you would be common law resident in a part of the UK. Turning then to the UK DTAs. Now, for those of you that don't know, in addition to all of the OECD model double tax agreements that the UK has, we do have a small number, just a small number, of what we refer to as capital taxes treaties, all of which tend to be older. And the older ones, like those with, I think, France, India, Italy, and Pakistan, contain a situs code. So this tells you where assets subject to the treaty are going to be deemed to be situate. So it says, ignore, say, the Indian law and the English law for the purposes of determining situs where the treaty is engaged. These are the rules, and then there's a set of rules set out. Now, again, my view is that those capital tax treaties are unlikely to determine the situs of crypto assets. And this leads me to an important distinction, which is this. Sometimes crypto assets are pegged to an underlying asset, or they might be a non-fungible token. So fungibles are very basically things like money. So if I have £10 and you borrow a £10 note from me and you give me a different £10 note back, it makes no difference to me. If I have a Picasso painting and you give me a Van Gogh back in exchange for my Picasso, that won't do. And that's the distinction between a fungible like money and a non-fungible. So non-fungible tokens will generally have sort of a number. They will be distinct from each other. They cannot be replaced with something else. So that's one case where there's a distinction where things like the UK DTAs might apply. The other one is where we have the value of the crypto asset pegged to something in the real world. So to go back to NFTs, one of these might be where you have an NFT that represents a small share in a piece of famous art. The situs there of this crypto asset is going to be the situs of the underlying art. And that would be the case whether or not the digital representation of that ownership was fungible or non-fungible, in my view, and also I think in James Kessler's view, if you read his book on non-residents and foreign domiciliaries. So that is where one has to make a distinction between things which are attached to the value of, or things which represent the value of real world objects, and things like Bitcoin, which are the value of which is more nebulous. And all I would say about that is, in the former case, I tend to see the crypto token not so much as a separate asset, but as a digital representation or record of that underlying real world asset. And so that's a really good distinction to draw when looking at how things are taxed, because in relation to both situs and source, that is going to make a huge difference to how they're taxed if it has something underlying it, potentially. So another point to note, cold wallets. Now, a cold wallet is a piece of hardware that in certain cases is physically required for a transfer of certain crypto assets. So I suppose at its most basic, it could be sort of a USB drive or something of that nature. And it will contain either the crypto asset itself or the key that is the means of accessing those assets. Now, the reason why this makes a difference is that in those circumstances, it can at least reasonably be argued that the location of the cold wallet is the situs for the crypto assets to which it relates. Now, this can be made to fit in with a more general sort of type of rule, because it's a technical situs, the cold wallet being where the crypto assets are dealt with, which looks a bit more like how we determine situs for things like debts. The downside of that is that it would allow taxpayers to use cold wallets to select the situs of the assets. So it would sort of be a crypto version of a specialty debt, and then that could be very useful in terms of inheritance tax. So we need to see some case law, or at least some better guidance on that, which we don't have a lot of at the moment. So turning to source. Source is already complicated, isn't it? But in the case of crypto, it may be even more complex. If you have a DTA with source rules, then my view is that that's likely to apply. And the source of income for the crypto is going to be governed by the rules in that treaty. Source, fortunately, again, so we have that's one get out. The other get out we have with source is if you are a UK resident under the statutory residence test, then it is likely to be the case that it really doesn't matter what the source of the income is, because it's going to be taxable in the UK anyway, because you're being taxed on your worldwide income. And of course, whether we get the Conservative changes or the Labour changes, the people who are going to be taxed at source, taxed on the basis of their worldwide income is only going to increase, which means that this problem is going to become a less concerning one in years to come. Notwithstanding that this is possibly a more minor practical problem, there's been a lot of interest in this. So every source of income has a location for tax purposes, and in most cases, it's easy to identify the location, normally determined by reference to the location of the assets and activities that are used to generate the income. But trading income has always been problematic in this context because income generating activities, not just for crypto, may be spread across jurisdictions. So an example of that would be São Paulo Brazilian Railway and Carter, which is now quite an old case, where there was a railway company where the railway was situated in, I assume, Brazil, but the company was an English company. And what happened there was it was held to be the case that the English company could be assessed in England on the whole of its profits because it carried on part of its business there. Yet it couldn't be doubted that so much of the profits of the businesses were in fact earned from running the railway in Brazil were derived from exercising a business in Brazil. And still less could it be doubted that the sums received by the company in Brazil were received from a source in Brazil. So effectively what you had there was, I think, prior to double tax treaties, a situation where you were just going to be taxed twice because the UK had a right to tax, but so did Brazil. And it couldn't, because the trade was carried out across jurisdictions, it couldn't really be divvied up in any meaningful way absent a tax treaty. So again, income arising from crypto assets, if it can be said that the business is carried out across jurisdictions, unless there's a double tax treaty or a unilateral relief that's going to help, it's likely that if it is trading income, it's going to be caught in more than one way. So just another thing to note, and I can see that I'm tight on time. I know we started a few minutes late. Source is potentially even more relevant where you've got a territorial system of tax. So the two examples that spring immediately to mind are Hong Kong and Gibraltar. But in those scenarios, as per Lord Bridge in Hang Seng, source is more relevant because that's going to say whether it's taxable in that jurisdiction or not, full stop. So it is, I think the reason I mentioned that is that it is very worthwhile looking out for how territorial jurisdictions end up dealing with the source of income from crypto assets, because it may be that they get there first because it's more important to them. And so the only other thing to notice is, and this is something that that I've already said, we're applying broad principles here. In Quong Mile, which is in fact another case from Hong Kong, it was said in CIR and Orion, Lord Nolan emphasised that no single legal test can be employed when ascertaining the source of a profit. The situation in which the source of a profit has to be ascertained are too many and varied for a universal judge-made test. Apart from the words of the statute themselves, the only constant is the need to grasp the reality of each case, focusing on effective cause without being distracted by antecedent or incidental matters. So really, what I'm saying there is we're not really any worse off. We're not really any worse off with crypto assets on source than we are with anything else. Now, just to pause before I give a brief introduction on when crypto is going to be taxed and how, before I hand over to Ben, we've got another question from David who says, on CITES, I recall it was often argued by some, not HMRC, that it should be where the private key is located rather than the residence of the owner. Do you feel this view is not holding water now? The case law that we have, and then people like the Law Commission, don't seem to be taking that view. I think it's more arguable if you have a private key located in a cold wallet, so you've got the actual hardware which has the key. But I think in absent the cold wallet argument, which I don't think is watertight, but I certainly think is arguable, if what you're trying to argue is you have the person who can use the key in one place and the private key in another place, I think that's going to be a very difficult argument to make. I think really, because what we're saying is we've got a person, they're going to use the key in place A, the key might be in place B, but ultimately it's going to be dealt with in place A. So I don't feel that that is holding water. My recollection is that the Law Commission don't take that view. Now, I don't agree with everything in the Law Commission report, particularly because I think where I really differ from them is that they say that crypto assets are not as shows in action. But on this point, I do agree with them. Yes, and David's just said this was mainly in point for those using the remittance basis. Yes, so of course it's likely to become less relevant as we go on. However, it is still relevant, but I think the other problem with it is, of course, HMRC don't like it because it allows you to effectively choose where you put assets. And so, as I said, I think my view is probably reasonably arguable if it's a cold wallet. I don't think it's likely to be strongly arguable in any other case. It's not something I'd plan on the basis of. If I was stuck, I might be willing to give it a shot in court. I hope that answers the question, David. So incidences on which crypto can be taxed. So trading income as it arises from a trade, if it's investment or passive income, on gains, on a disposal, and on a gift or on a death. So the same as any other asset, really. Now, in my notes, which you will be getting a copy of, I go into a lot of detail on determining whether or not something is a trade and applying this to crypto. And I'm going to leave Ben to go through those sort of basic tests. I also set out a lot of the OECD guidance because I think that's useful as well. And what I want to do, rather than take you through all of that, as I say, it is in my notes, I want to go through an example with you. And the example is this: a coin issuance. We've got two considerations: whether or not issuing a coin constitutes a trade, and if it does, what is its source likely to be? So in relation to the first of those, it's unlikely in most cases that a coin issuance event could be treated as a trade on the assumption that an entity is only making a single coin issuance. So we do have examples of single events constituting trades. The one that I always remember is the Brandy Syndicate one. They're generally unusual and are quite fact specific. But so it's unlikely to be the case. However, there are three scenarios in which I say it does risk being a trade. The first one, where you have a single entity which makes numerous coin issuances, though again, I'm not convinced about that one because that might be seen to being akin to, say, issuing shares. Where you have a single coin issuance which has sufficient trading factors to render it a trade. And finally, for a company which creates numerous entities to make multiple coin issuances. So that's scenario one, but with a bit of fancy tax avoidancy steps in there, which I'm sure somebody's going to do. Now, it's important to note that in my view, before any of those three scenarios could be considered a trade, there would need to be other trading factors present. In particular, whether or not there had been a commercial purpose in issuing the coins. And it's not enough that the issuance is intended to be commercial in some sense, but that the act of issuing the coin is intended to yield a return in the course of business. And in order to determine that, you would need to look at considering the relationship of the coin issuance to the taxpayer's trade. So there are circumstances when a coin issuance could include an element of trade. If it's in a commodity of a kind which is normally the subject matter of a trade. So, for example, if the coin relates to an underlying asset which is normally the subject matter of trade. And so to pause there, issuing coins can be a trade. Something else that can be a trade, mining. Mining can be a trade. Staking, which is the other method of creating the assets. Staking can be a trade. And in some ways, my view is that mining and staking are more readily identifiable as a trade. But let's go back to our coin issuance. What's going to be its source? Now, and again, the difficulties that we have in identifying the source of income that forms part of a trade, it's not a new problem. It's maybe expressing itself in a slightly different way, but it's not it's not a new problem. There have been several things that have been proposed. The starting point is going to be that profits will have arisen or derived from the place where the service was rendered or the profit-making activity carried on. If that profit-making activity is issuing the coin, this is going to be determined by how the coin is issued. It may be that ultimately we end up with a test which says, well, the situs of the coin is also going to be its source, but it's more likely that we're going to end up in a multifactorial situation as we have with debts. So that's all I want to say about that. I'd love to talk to you about the crypto asset reporting framework, but again, it's dealt with in detail in my notes. And I'm going to hand over to Ben, who I'm sure is going to have lots of very exciting things to tell you. Thank you for listening.
Thank you, Harriet. And I'll just, please bear with me. And just please bear with me, I apologize. Okay, yeah, welcome to my presentation on cryptocurrency and taxation. I'm Ben Symons, I'm a barrister at Old Square Tax Chambers, and I'm presenting with Harriet Brown, who is also a barrister at Old Square Tax Chambers. How are cryptocurrency gains and losses taxed? Essentially, there are three possibilities. The first possibility is that a gain or loss is a gambling gain or loss. Every taxpayer that makes a gain would like to say it's a gambling gain because gambling gains are tax-free. As we'll discuss in a minute, this is highly unlikely to be the correct tax treatment. The second possibility is that a gain or loss is a trading gain or loss. For most individual retail taxpayers, this will not be the correct tax treatment. It will be the correct tax treatment for hedge funds and professional traders, but most of the investors and traders active in the market are individual retail investors who conduct this activity part-time and at the weekends. The third possibility is that a gain or loss is a capital gain or loss, and realistically, this will be the correct tax treatment for most individual retail taxpayers. A little bit more on whether a gain or loss could be a gambling gain or loss. From a factual point of view, it will be very difficult for most taxpayers to show that they are gambling in cryptocurrency. Most of the clients that you will deal with will trade significant amounts of cryptocurrency, and typically individuals who trade significant amounts of cryptocurrency have some sort of a strategy. They rarely trade blindly. And for this reason, from a factual point of view, it'll be very difficult for them to maintain that they are gambling in cryptocurrency. Even if you succeeded with that factual argument, you'd be then into a very difficult legal argument. There is very little legal authority to support the view that gambling in cryptocurrency, and that the cases that exist relate to gambling in shares, but to use those cases by parity of reasoning to say that a gambling gain could be tax-free. The statements that are made are in Salt and Chamberlain, dating back 30 years, and they were made by way of obiter. There is no case directly in point on this issue. Then even if you succeeded with that argument, you'd likely be caught by the capital gains tax provisions. And that's because the exemption for gambling in the capital gains tax provisions doesn't apply to gambling in shares or cryptocurrency. And I go into those arguments in a lot more detail in my book, and I have a link to that in my slides. And my slides along with Harriet's notes will be circulated after this webinar. Could a taxpayer be realising trading gains and losses? Realistically, for most individual taxpayers, this will not be the correct tax treatment. If a taxpayer wishes to sustain the view that they are trading in cryptocurrency, and they would generally only want to do this where they're making a loss, because if they're running another business, they can offset that loss against their other income, they need to demonstrate 4 things. They need to show that they conducted the activity on a full-time basis. They had a basic strategy that they stuck to. It doesn't have to be a scientific strategy. They did some basic bookkeeping, and they had a business plan, ideally a written business plan. If a taxpayer is able to demonstrate those 4 things, they have a reasonable shot at a trading argument. The tribunal has a wide margin of discretion as to what is trading, what is or is not trading. But if you are able to demonstrate those 4 things, you have a reasonable basis to give the tribunal jurisdiction to determine that you're trading. An interesting case on this was the 2015 case of Ali and HMRC. In that case, Mr. Ali was a pharmacist. He ran a pharmacy business full-time, and he moved into an office upstairs and he traded shares full-time. He got someone else in to run his pharmacy business. Over the course of 2 years, he made losses of around £2 billion, and he sought to claim those losses, and HMRC sought to deny him the use of those losses. The matter went to the tribunal, and Mr. Ali got through by the skin of his teeth. He showed that he was conducting the activity on a full-time basis. He was trading on a full-time basis. He had a very simple strategy of relying on broker research reports. It wasn't particularly scientific, but it was a strategy, and he stuck to that, and that was sufficient. He did some basic bookkeeping, and he articulated an oral business plan at the tribunal. He was a little bit lucky. That was a marginal case, and he got through by the skin of his teeth. But it is possible to maintain a trading argument if you can show those 4 things. The third possibility is that gains and losses are capital gains and losses. And realistically, this is the correct treatment for most taxpayers. Gains will be taxed at the concessional rate of 20%, and losses can be carried forward indefinitely, but must be claimed within 4 years. One thing to be mindful of here is the capital gains tax pooling rules. Most of the taxpayers I've dealt with in this space execute tens or hundreds of transactions in a very short space of time, less than a month, and they will be required to calculate their gains and losses according to the capital gains tax pooling rules. That is something to keep in mind, because, well, if you don't do that, you are subject to an HMRC investigation. They will take issue with that. NFTs and VAT, this is an emerging issue. What is an NFT, a non-fungible token? I've started here with the Oxford Dictionary definition of what fungible means. Fungible means replacement by another identical item, mutually exchangeable. So a non-fungible token is the opposite of this. It is a token that is completely unique. It is not like any other, and it will be based on blockchain technology. 90% of NFTs relate to either artwork or sports memorabilia. And this is one area of the crypto ecosystem in which there is longer-term economic value. It is hoped that NFTs will revolutionize the online art markets and possibly the online sports memorabilia market as well. Manchester United, released their own range of NFTs, sports memorabilia NFTs. And in April 2021, Christie's sold the NFT artwork Every Day's The First 5,000 Days for $69.3 million. So there is serious interest in this space. And one of my clients is an NFT artist who makes decent money selling NFT artwork. And there are 3 reasons there is so much interest in NFTs in the online art space. First, they enable the buyer to get clear title to the product. Second, they enable the buyer to trace back and prove the provenance of the artwork. And third, they enable the artist to get paid a royalty every time the artwork is unsold. It is hoped that NFTs will create an orderly online market for the sale of online art, electronic art. This is the hope. So what are the VAT issues around this? Most NFTs are sold through online marketplaces like OpenSea and Nifty Gateway. These marketplaces are marketplaces for the sale of electronic artwork, NFT-based electronic artwork. And, well, there are people conducting businesses on these platforms. One of my clients conducts a business as an NFT artist. Another one conducts NFT arbitrage trading. And well, the first issue is, how should the NFT be characterized for VAT purposes? If you work your way through Schedule 4A of the VAT Act, the position you get to is that an NFT is an electronic service. As such, it should be standard rated. It should be subject to VAT where the person making the sale conducts a business. And could the second-hand goods scheme apply to that person? Well, the answer is no, because the second-hand goods scheme only applies to physical goods. It does not apply to purely electronic goods. So if the NFT is a purely electronic artwork, the second-hand goods scheme won't apply. It could potentially apply if the NFT acted as an identifier for an underlying piece of artwork, but at least with OpenSea and Nifty Gateway, most of the NFTs being sold on those marketplaces are electronic NFTs. The second issue is, where is the place of supply? This determines where VAT or GST or sales tax should be paid. And in relation to these online marketplaces, buyers of NFTs can and are anywhere in the world. They can be in the UK, in the EU, in the US. People are buying NFTs all around the world. And that means VAT or GST or sales tax, as the case may be, is payable in jurisdictions all around the world. And this brings us to the third issue, which is, who has the obligation to pay VAT? Is it the marketplace on which the sale takes place? Or is it the person conducting a business on the marketplace? The short answer is that it is probably the marketplace, and that follows from Article 28 in conjunction with Article 9A of Implementing Regulation 282 of 2011. These provisions put the obligation to collect VAT on the marketplace in most cases. What is happening at the minute is that, well, the marketplaces don't really regard it as their responsibility. So for the most part, they're not paying VAT. The people who conduct business on these marketplaces, this creates a difficulty for them if they want to pay VAT, because if they approach the exchange will say it's nothing to do with us. They're unable to identify the location of the buyers of these NFTs. So the person conducting the business can't find out which jurisdiction they should be paying VAT in and how much VAT they should be paying. So this is an emerging compliance issue. It's one that revenue authorities haven't woken up to yet, but it probably will become an issue at some point in the future. Non-domiciled individuals and inheritance tax, or as this relates to crypto assets. UK resident non-domiciled individuals are only subject to inheritance tax on their UK assets. They aren't subject to inheritance tax on their non-UK assets. So a non-domiciled individual would like to, a UK resident non-domiciled individual would like to say their cryptocurrency is a non-UK asset, because if they pass away, it won't be subject to inheritance tax. So this raises the question of, well, where is cryptocurrency situated? And I'll go through this on my next slide. The situs of decentralized cryptocurrency has been a vexed issue. There are a number of possibilities. The first possibility is that the location of the person who holds the private key or who controls the private key determines the location of a crypto asset. The second possibility is that it is the domicile of the taxpayer that determines the crypto asset. The third possibility is that it is the residence of the taxpayer that is the touchstone for determining the situs of a crypto asset. And the fourth possibility is that you could adopt a multifactorial approach. You could look at the residence of the taxpayer who holds the asset. You could look at their domicile. You could look at the location of an exchange on which they bought that crypto asset, the residence and the domicile of the seller. You could potentially look at many different things in taking a multifactorial approach. There is no clear historical precedent. As Harriet said, HMRC maintains that residence is the appropriate touchstone for determining the situs of a crypto asset. The balance of UK authority and probably international authority as well maintains that residence is the correct touchstone for determining the situs of a crypto asset. This matter is almost, we're getting a number of authorities from the Chancellery Division of the High Court in relation to injunction cases where it has been suggested that residence is probably the correct touchstone. These are unhelpful for non-domiciled individuals, and it's a shame we haven't had a tax case on this yet. But there probably will be a tax case at some point. But most recently in Tulip Trading, Justice Falk said she preferred the view that residence was the correct touchstone. And in giving that view, she took into account the location of the person who holds the private key. And well, she considered that the residence of the taxpayer who holds the crypto asset is probably the better touchstone. And ultimately, the judges giving these decisions are drawing on a view given by Professor Andrew Dickinson in his book, Cryptocurrencies in Public and Private Law, as to where cryptocurrency is situated. The matter wasn't fully argued before the Court of Appeal, but Lord Justice Burst did give implicit endorsement to Justice Falk's view. This doesn't mean the matter is settled. The matter isn't quite settled yet, and there are other arguments, and those arguments, Harriet's been through those other arguments. They're also detailed in my slide. There are other arguments that can be made, and we will see a case on this at some point. Unfortunately, the cases in the Chancellery Division of the High Court are making this more and more difficult. I should point out, for an NFT, there is a smart contract that underlies the NFT, and there may be an argument that the jurisdiction where the contract could be enforced is the location of the crypto asset. That may be, a slight. It was Harriet went into this. This is a slight differentiation for NFTs. The situs of an NFT may be different from just a normal decentralized cryptocurrency like Bitcoin. The analysis in this slide applies to a decentralized cryptocurrency like Bitcoin. For NFTs, there are other good arguments. If there is a smart contract and the smart contract can be enforced in a particular jurisdiction, it is likely that it will be situated in that particular jurisdiction. And the answer may be different for other types of cryptocurrencies as well. For instance, Ripple is not a decentralized cryptocurrency. It is largely produced by servers in the US, and it is likely to be situated in the US. So it does depend on where cryptocurrency or a crypto asset is situated. Does depend on the type of cryptocurrency or crypto asset. Non-domiciled individuals and capital gains tax. Where is cryptocurrency situated for the purposes of the non-domiciliary crypto capital gains tax rules? The capital gains tax rules prescribe the situs of most assets for the purposes of the capital gains tax rules, including the non-domiciliary regime. And well, if you go to 275, 275A and 275B of the Taxation of Chargeable Gains Act, that's where you'll find those provisions. In relation to crypto assets, there is a decent argument either way as to whether cryptocurrency, a decentralized cryptocurrency like Bitcoin, could be UK situate or non-UK situate. My own view is that the view that a decentralized cryptocurrency like Bitcoin is UK situate on the basis it follows the residence of the taxpayer, it's the slightly better argument. But for the purpose of the capital gains tax provisions, there is a good argument the other way, and we may see a case on these provisions at some point as well. And the solution to this problem is to hold cryptocurrency through an excluded property trust, an offshore excluded property trust. Ideally, you would hold cryptocurrency that way from the start. It is possible to transfer cryptocurrency into an offshore excluded property trust. You're likely to run into issues with the transfer of assets abroad provisions and possibly other anti-avoidance provisions. But that is the way to get around this problem and give cryptocurrency a non-UK situs. A little bit on the crypto asset reporting framework. This is something that Harriet has already talked about, and she is writing a book on. But in relation to the crypto asset reporting framework, at a very high level, it was published by the OECD in October 2022, and it is a FATCA-like regime for crypto assets. It is designed to give revenue authorities around the world transparency into cross-border crypto transactions and what is happening in offshore jurisdictions in relation to crypto assets. At present, revenue authorities have very good visibility in relation to what happens in the banking system in relation to cross-border transactions and in offshore jurisdictions. That's from the Common Reporting Framework. But the crypto ecosystem sits outside the traditional banking system. Most exchanges and players in the crypto ecosystem don't interact very much with the traditional banking system. And there is a complete lack of transparency from a revenue authority's point of view in relation to what is happening in the crypto ecosystem. If the exchange is located in an offshore jurisdiction, it is very difficult for HMRC to find out what is going on. And this is what the CARF is directed at. HMRC recently conducted a consultation in relation to how the UK should implement the CARF, and bilateral and multilateral instruments will follow from this with automatic exchange of information. Timelines have not yet been agreed, but the OECD aims to have member countries implement this by 2027. And there are essentially 4 pillars to the CARF. The first pillar, which assets are covered? Almost all cryptocurrency, almost all crypto assets. So cryptocurrency, NFTs, capital raising tokens, and tokenized assets. Almost every cryptocurrency you could think of. The 2 exclusions are central bank digital currencies and specific electronic money products. At present, stablecoins won't fulfill the definition of or most stablecoins won't fulfill the definition of a specific electronic money product. And that's because most stablecoins are algorithmic stablecoins and they can't be redeemed at par value upon request. But that may change in the future. What are the reportable transactions? There is aggregate annual reporting by crypto asset type and number of transactions in relation to the conversion of crypto to fiat transactions, the conversion of crypto to other crypto assets, and where there is a transfer of a crypto asset as either payment or as a gift. What are the crypto reporting entities? Any business effecting an exchange of a crypto asset. That will be exchanges, brokers, and possibly custodian and wallet providers, depending on their involvement in whether they are involved in transferring a crypto asset. What due diligence does a crypto reporting entity need to undertake? Essentially, they need to get documentation to prove the identity and tax residence of the individual or company trading on their platform. It will be a self-certification framework where the platform or broker has to get a passport as proof of identity and something to prove tax residence, probably a utility bill, proof of address, something like that. The crypto reporting entity will be under an obligation to conduct reasonableness checks. So if there is a conflict between those two documents, the crypto reporting entity will have to undertake further due diligence. It's very similar to KYC and anti-money laundering procedures. So that's the CARP at a very high level. Where is HMRC enforcement activity at present? As of June 2024, HMRC has issued over 8,000 letters to individuals suspected of making cryptocurrency gains but not declaring them. So HMRC is actively looking into the tax affairs of individuals it believes have made cryptocurrency gains. HMRC also published a publication in January 2024, encouraging individuals to declare their cryptocurrency gains. If you deal with taxpayers in this space, there are a lot of people who have very funny beliefs. You know, there are a lot of people who think because they invest in cryptocurrency, they don't have to pay tax, they don't have to declare their gains. People have all sorts of funny beliefs. So we're likely to see, investigations and possibly tribunal cases in this area. Another big area of activity is non-domiciled individuals. HMRC is actively conducting investigations into non-domiciled individuals and particularly their treatment of crypto assets, particularly whether they can use the non-domiciliary regime to shield their gains from UK tax. And this brings me to my final slide, which is what are the hot cryptocurrency litigation issues? Well, initial coin offerings, they were hot back in 2019. Is the initial coin offering a prepayment or a single purpose voucher? If yes, VAT is payable up front. If no, VAT is payable when the coin is redeemed. That's for a utility token. It's possible we may see more cases on this if initial coin offerings become a thing again. VAT on NFTs is an emerging issue. It's not one revenue authorities are taking much interest in right now, but that will probably change going forward, and that's one to think about for the future. In terms of corporate tax, income tax, non-domiciled individuals, where is cryptocurrency situated? That is a big issue, and it is one HMRC is looking at. And trading gains and losses, gambling gains and losses, we may see cases on this as well. Well, it's possible we will see a case or two. If somebody has taken the position that their gain is a gambling gain, that is something HMRC will definitely challenge, and they probably they do have the better argument there. They have a very good argument. We may see cases on whether losses are trading losses or capital losses. So they're all areas of interest for HMRC. And that is my presentation, and I'm happy to circulate these slides along with Harriet's notes after this webinar. There is one question. I can see Harriet has said she'll provide more detail after the webinar on the CARF. And I'm just looking, I can't quite see. Harriet, we did get a question from, forgive me if I get the pronunciation wrong, Aif Walsh from EY before the seminar. I apologise.
We did, yes. Do you want to just read that out, Ben?
Yeah, please bear with me. Sorry, just bear with me, please.
Oh, what? No, don't worry. I've got it here if you haven't. So there were two questions. First off, most of the commentary and HMRC guidance relates to the disposal of cryptocurrency and the CGT consequences. Does the panel think that the same analysis would apply on the acquisition of cryptocurrency, e.g. if a UK resident non-domiciliary acquired cryptocurrency using remittance taxable funds, would this be a remittance to the UK? My view, Aoife, is no, I don't think it would. Because my view is that I mean, all other things being equal, is that the remittance basis rules in ITA would override the sort of ill-defined common law basis on which we're looking at this. So that's my view. I think Ben has a different view, but I'll let him speak to that.
Yeah, if I do have a different view. I think the taxpayer has the more difficult argument on this point, and that is because, yeah, I mean, I would see the taxpayer has the more difficult argument in the sense if we take the position a UK resident taxpayer holds cryptocurrency directly, if it is a UK asset, I think a court or tribunal is more likely to find that the asset has been either bought into the UK or received in the UK under the statutory remission provisions, and that's my basis for that view. You know, the matter is not totally clear, and I also understand that HMRC hasn't yet taken that, or HMRC hasn't taken that point with any of the investigations I'm aware of, but it's a potential issue.
And then the other question that we had also from Aoife in advance, thank you for sending them in advance, Aoife, giving us some time to look at them. The Law Commission recommendations suggest that cryptocurrency is not a shows in action, but could be another form of property. There is a recent Singaporean case, Bybit FinTech, which held that cryptocurrency is a shows in action. Does the panel think that this could be persuasive in the UK? So, Aoife, this is a case from Singapore that's very close to my heart, because I just, notwithstanding how erudite the Law Commission is, I think they're wrong about this. I really don't see on what basis it is not a shows in action. It has all of the hallmark features, which I think really is what the court in Singapore said. It has all of the hallmark features of a shows in action. And by suggesting that it's sort of a wibbly wobbly something else, the Law Commission isn't being terribly helpful. That being in that, I'm not denigrating them, that they know far more than I do. But what I'm saying is, as far as I can see, most, of course, not all cryptocurrencies, because it's fact dependent, but most exchange tokens, for example, have all the features of a shows in action. And to me, that they are a shows in action. So to suggest that there's some special category for them is, in my view, unhelpful. And I think the Singapore court, Judge J.R. Rethnam, took a very sensible approach. I mean, and what he said was, in essence, that where you have a crypto asset, the holder has in principle an incorporeal right of property recognizable by the common law as a thing in action, and so enforceable in court. A shows in action. That's what a shows in action is. It's a bundle of enforceable rights. So I really hope that case would be persuasive in the UK, because I think it's correct. But I do know that the English courts place a great deal of reliance on what the Law Commission says, and rightly so. But that doesn't mean they can't get something wrong. And in this case, Aoife, I would strongly argue that Bybit FinTech is correct, and I would hope that courts would agree with that. So there's a legal answer and a practical answer. The legal answer is yes, absolutely. The practical answer is I hope so, but they do take the Law Commission very seriously. So I hope that helps.
I might just make a couple of comments as well. I think for an NFT, there is a smart contract that underlines the NFT, and if the smart contract is enforceable in a particular jurisdiction, I think there is a good argument that it is situated in that jurisdiction, and that would, I mean, that would be a chosen action. So I think certainly for an NFT, there is a good argument that it can be a chosen action, and it can be if it's enforceable in a particular jurisdiction, that is where it is situated. In relation to whether cryptocurrency more generally can be a chosen action, I mean, I'd agree with Harriet. The law isn't really settled in this area. In AA versus the AA and Persons Unknown in 2019, Justice Bryan said that he recognised cryptocurrency as a category of property, and he followed the UK's jurisdictional task force on crypto assets. And at paragraph 84 of that statement, it says that crypto assets are not a chosen action in the narrow sense of the term, but it leaves open the question of whether it could be a chosen action in the wider sense of the term. So, yeah, the short answer is the question is definitely open in UK law, and it's open to UK courts to consider that the Singaporean decision in Bybit FinTech Limited, along with everything else. It's possible a UK court would definitely find it's property. They may well find it's a chosen action as well. And if it is a chosen action, then it is situated, or if they were to find it was a chosen action, it would be situated in the jurisdiction in which it can be enforced. I suspect the answer in many cases may not be different to the residence of the taxpayer, but it all depends on the facts and circumstances. And just checking the Q&A again. Yeah.
Apologies. Sorry, I was just saying I don't think we've got any more questions. We have run over slightly. Thank you so much for attending. If you have any questions, do feel free to get in touch with me, and we hope this has been helpful.